just would like to know a little more information about you guys. So let's take a quick poll to know a little information about you. Please let us know if you're here as a new HR personnel, or if you're here today to learn about FLSA for the first time, or if you're here to brush up on FLSA. Awesome. We will be closing the poll shortly. Okay, awesome. Thank you guys so much for submitting your responses. I do apologize. Caroline, if you could share with us the results. Oh, here are the results. Seeing that most of our audience members are already an HR expert and here joining us today to brush up on their FLSA knowledge and also to listen in for the new proposed changes for the 2024. Either way, thank you guys so much for, again, submitting your responses. We will be discussing the importance of Fair Labor Standards Act. I keep saying FLSA. That FLSA is an acronym for Fair Labor Standards Act. If you're not familiar with FLSA, again, no worries. We'll go over the key importance of FLSA. If you're already an expert, again, no worries, because we will be going over the new proposals for 2024. Awesome. So again, FLSA affects you as the employer or affects you as the employee. It is far-reaching and affects you, again, as either having a full-time position, part-time position, public or private sectors. I just wanted to give you a warning. If you're in HR, you're probably aware that there are a lot of acronyms out there. And it's, again, a lot of these acronyms are very important in our industry. So for FLSA, WHD is an acronym. So what is or who is WHD? WHD stands for Wage and Hour Division. They are an office within the DOL, which is Department of Labor. WHD administers and enforces standards for wages and working conditions regardless of one's immigration status. You may wonder how FLSA came about. It's a very common and popular topic amongst the workers and leaders. Many voiced ideas similar to FLSA, and finally in 1938, President Roosevelt signed a bill which later became known as FLSA, or Fair Labor Standards Act. The bill was passed as a necessary means to maintain livable standards for the general health, well-being, and efficiency in the workplace. Additionally, standards for overtime pay and minimum wage created employment opportunities during a critical time. I believe that bullet point from the last slide was mentioned. I did want to have a quick history pop quiz. What historic event happened in 1938? If you've said World War II, you are correct. It was actually in the middle of World War II. It's the time of the Great Depression. So FLSA helped tremendously by creating more opportunities for families to make a living. FLSA has protections for employees in different areas, as you can see here, such as child labor. We went over the minimum wage and overtime, defining hours worked, worker classifications, record keeping, and the most recent addition, the Nursing Mothers Act, also known as the PUMP Act. There are more standards that we simply do not have time to go over them all. If you have any specific questions, be sure to reach out to us. Child labor standards under FLSA protects the employment of youth and children, restricting the type of work they can perform at a specific age. There are restrictions to their hours and includes mandatory rest breaks. The regulations are different for agricultural versus non-agricultural industries. Here are some examples for the age-specific types of employment. By age 13 or younger, they can start babysitting or acting. Around the ages of 14 to 15, they can work in grocery stores, restaurants. Ages 16 to 17, any jobs that are not considered hazardous. And at the start of age 18, the restrictions are lifted. There are restrictions, again, based on the hours for the youth, which are the ages 14 to 15. They can work from 7 a.m. to 7 p.m., up to 3 hours on a school day, or up to 18 hours during a school week. They can work 8 hours on a non-school day and up to 40 hours on a non-school week. The next topic we'll be discussing is with the protections around minimum wage and overtime. The current non-exempt pay rate is at $7.25 per hour. Tipped employees have their own pay rates. However, the thing you need to be very wary of is that the tips and their base rate must be $7.25 per hour or above. Non-exempt employees overtime, they are calculated once an employee works over 40 hours in the work week. The pay rate is typically their regular pay rate times 1.5, or also known as time and a half. There are different overtime calculations, which depends on other earnings or if their pay rate is based off of piece rate. Again, we will not be going into details because that could be another separate webinar in itself. Just a key information for you to look out for: some states and cities and counties have their own minimum wage rates that may be higher or lower or even equal to the federal minimum wage. Once you know the pay rate, choose the rate that benefits the employees the most. I want to go over some of the examples for the minimum wage. If we look at California's minimum wage, they are at $15.50 per hour. Therefore, non-exempt employees in California, they must be paid or make $15.50 per hour, which is greater than the federal minimum wage. If you look at another example with Georgia, Georgia's minimum wage is at $5.15 per hour. Non-exempt employees in Georgia must make the federal minimum wage, which is $7.25. Again, the federal wage is greater than the Georgia's state minimum wage. So we take the pay rate that is the most beneficial to the employee. As a reminder, again, there is a county minimum wage, so be sure to research or even ask us. And once you find that pay rate, choose the rate that benefits the employees the most. Alrighty, I think we are taking another poll for another scenario. So for New Jersey's minimum wage, currently it's at $14.13 per hour. Which rate would you pay your New Jersey employee? Is it A, federal minimum wage of $7.25 per hour, or B, New Jersey state minimum wage of $14.13 per hour, or C, whichever minimum wage benefits employees the most, or D, both B and C? Please submit your responses here. Awesome. So if we could close the poll. Alrighty. So we have some people that said B, New Jersey state minimum wage of $14.13 per hour, or C, whichever minimum wage benefits employees the most, and majority answered D. So the correct answer is D, but you're also not, you're also correct if you answered B and C. So with the different federal minimum wages, you might be wondering how frequently the minimum wage increases. FLSA has increased the minimum wage gradually over the years, and we will continue to see it rise. When FLSA was first established, the minimum wage was at 25 cents, and it gradually increased to $7.25, which is as of July 24th of 2009. Later in this webinar, we will be discussing the new proposed 2024 increases, which does, again, go over or includes the federal minimum wage increase. For now, let's go over some of the definitions of the terms in FLSA. Defining the work week. So a work week is a work period which consists of 7 consecutive 24-hour days, or 168 hours. The work week can begin at any day of the week or at any hour of the day. Once the work week is defined by the employer, the work week is a set period and cannot change. It is important to understand what is defined as worked hours or hours worked. Hours worked are considered any time an employee is required to be on an employer's premises, on duty, or at specific workplace. This also includes any time an employee is permitted to work regardless of whether he or she is required to do so. Hours worked includes employees' regular scheduled hours and overtime. The next topic we will go over are the different types of worker classifications. FLSA has specific criteria with worker classifications. There are tests and standards for each classifications to determine whether an employee is exempt or non-exempt. For the overtime pay, minimum wage, or both provisions, and child labor. WHD looks at the salary level, salary basis, and the job duties. Not only do they look at the salary and the job duties that matters for the classifications, it is also very, very, very important that their daily functions passes the test as well. So we are talking about exempt and non-exempt statuses. To define exempt status, exempt employees are also commonly known as salaried employees. They are usually excluded, or they are excluded from minimum wage, overtime regulations, and other rights and protections granted to non-exempt employees. Exempt positions usually consist of executives, supervisors, administrators, or administrative type of work, professional, and outside sales positions. Again, job titles do not determine the FLSA exemption statuses alone. Okay. For non-exempt positions, they are also known as hourly positions. They are not exempt from minimum wage and overtime regulations listed under FLSA. This means that employers must pay their workers who are non-exempt at least the federal minimum wage, which again is at $7.25 per hour for each hour they've worked, and overtime pay of no less than a time and a half for the employee's hourly rate for any hours 40 hours and above. So the first exemption or type of exemption that we'll be going over is for white collar exemptions. There are three main criteria that must be met for the position to qualify as a white collar exemption. One, they must receive payment on a salary basis, with some exceptions. Two, the salary must be paid at a minimum of the current rate, which is $684 per week, or annually $35,568. Again, with some exceptions. Number three, they must pass the primary duty test created for each exemption statuses. There are specific types of the white collar exemption statuses that we'll be discussing next. So exemption type number one, the executive exemption. To qualify for an executive exemption, an employee must meet these criteria. Must be paid on a salary basis, again at a rate of $684 per week. They must pass the primary duty test, which is to manage the enterprise or manage a customarily recognized department or subdivision of the enterprise. And number three, customarily and regularly directs the work of at least 2 or more full-time employees or their equivalent. Okay. Exemption number two, administrative exemptions. To qualify under the administrative exemptions, the employee must meet under these criteria. Paid on a salary basis, again at a rate of $684 per week. Pass the primary duty test, which is to perform office or non-manual work directly related to the management or general business operations for the employer or the employer's customers. And the primary duty test includes the exercise of discretion and independent judgment with respect to matters of significance. Exemption number three, professional exemption. To qualify for a professional exemption, an employee must meet these criteria. Again, salary basis. Primary duties must meet their learned professional or creative professional qualifications. What's learned professional? So learned professional are primary duties that perform work that requires advanced knowledge. For example, specific fields like scientific fields, or there's a field-specific knowledge. The work must be predominantly intellectual in character. Work requires a consistent exercise of discretion and judgment. And to define exercise of discretion and judgment, it means that the employer isn't directing them of how to do their jobs. They should be able to determine, diagnose what is required of them in that field, the issue, and be able to, perform their job duties accordingly. Creative professionals. These job duties are around being innovative, imaginatory, being original, and having the talent to recognize any artistic or creative responsibilities and duties. Exemption type number 4, computer-based exemption. To qualify for computer-based exemption, an employee must meet these criteria: be paid either A, on a salary basis or a fee based of $6.84 per week, or B, on an hourly basis at a rate that is not less than $27.63 an hour. They must be employed as a computer system analysis, computer programmer, software engineer, or something similar to that skilled worker in the computer field. The primary duties must consist at least one of the following: the application of system analysis, procedures, and techniques, including consulting with users, determining hardware, software, or system functionalities, design and development, documentation, analysis, creation, testing, or modification for computer systems or programs, including prototypes, system design specifications, again, more designing work, documentation, testing, creation, modification for computer programs related to machine operating systems, or a combination of the duties that requires the same level of skills. Exemption type number 5, outside sales exemption. To qualify for outside sales exemption, they must pass the primary duty test, which is making sales defined under the FLSA, or obtaining orders or contracts for services or for the use of facilities for which is considered to be paid by the client or customer. Customarily or regular engages away from the employer's place or places of business. Again, frequently the outside sales representatives will meet their clients at their locations to provide product or services. Exemption type number 6, highly compensated exemption. To be qualified under the highly compensated exemption, the employee must meet these criteria: earns a total annual compensation of $107,432 or more. Employers may not use non-discretionary bonuses and incentive payments such as commissions to satisfy the annual compensation. The weekly payment of $684 must be paid to its entirety. The primary duty test is to perform office or non-manual work, and part of the exempt duties test is that they are under the executive, administrative, or professional employee. The next exemption status I will talk about is the independent contractor exemptions. So independent contractors falls outside of FLSA typical employment classification. Accordingly, FLSA does not require covered employers to pay an independent contractor the minimum wage or overtime pay under the sections 6A and 7A of the Act, or, matter of fact, to keep records regarding the independent contractor's work under Section 11C. The independent contractor label does not make the worker, again, protect under FLSA. There are distinguishments between employee and contractor. Again, FLSA doesn't define the term independent contractor, but they do define what makes up an employee and things to look out for. And again, they are looking, when brought into court, they are looking at the economic reality analysis, which we will define a little bit later. Awesome, right here. Department of Labor has the economic realities test. This determines the classification, whether an employee is, classifies whether the position is an employee or classifies the position to be a contractor. Employees are protected under federal and state laws. Contractors are not protected under the same laws. Again, the reality of the work that a person performs determines the job requirements. The job title, again, does not define the exemption statuses. Here are some sample questions to determine if the worker is either an employee or a contractor. Does the business control when the work must be done and how long it will take? And if so, how much control does the business have? So if the answer is yes, then this position or the worker is an employee. Does the business reserve the right to assign the worker with additional projects? Does the worker supply additional help when necessary, such as hiring other people? Or does the business provide them? How does the parties handle taxes? So if the employer or the business assigns additional tasks, if the employer is providing resources, if the employer is deducting taxes on their payroll, most likely the position will be defined or labeled as the employee. Again, if the answers are the opposite, then they are defined as contractor. The next test, IRS Common Law Test. This is a guide that the IRS uses to determine if a worker is classified as an employee or independent contractor. It's composed of 3 categories to define how much control the employer has: behavioral control, financial control, and the type of relationship. So behavior control, a worker is likely an employee if the employer controls what the work the employee does and how they do it. If an employer directs and controls only the result of the work, the worker is defined as an the worker is defined as an independent contractor. Financial control. Independent contractors can agree with an employer over when and how they are paid, generally a flat fee or a project or an hourly fee. And they are seeking out business opportunities and advertise their services in the market. Employees have an element to control, employers have an element to control over the employee's finances, such as the take-home salary or wage, and employers also holds taxes and benefits. Okay, and type of relationships. The best practice is to write a contract, and be warned, the IRS does not consider a written agreement as proof. Instead, the IRS looks at the direct relationship between the employer and worker. Again, going over the behavioral control, financial controls, that's what's going to define what the relationship between you and the worker. Independent contractors do not receive employee benefits such as paid vacation, pensions, disability insurance. If you do provide worker benefits, you should be classifying them as employees. Lastly, as when a worker's relationship, when a business is expected to extend indefinitely, they are likely an employee. Conversely, independent contractors are hired for a specific period or projects. It's very, very tempting for business owners to misclassify workers to avoid paying federal taxes. It will only blow back on employers because IRS will hold the employers liable for employment taxes for the entire time the employees are misclassified, plus penalties, and you risk, employers risk getting sued as well. So next, record keeping. FLSA requires employers to record wages, hours, and other items as specified in DOL record keeping regulations. Most information is generally maintained by the employers in ordinary practices and in compliance with other laws and regulations. The records do not have to be kept in any particular form, and time clocks do not necessarily need to be used. Golden rule. The golden rule for record keeping is to keep employee records for 7 years. The best practice is to keep everything involved with the employee, such as recruiting, employee files, resumes, performance, anything like that together for 7 years. Typically, time cards and other information, which includes the wage rates, job evaluations, seniority, merit systems, and collective bargaining agreements are required to be kept for 2 years, and medical records are required to be kept for 5 years. Certain medical records must be kept for 30 years after termination, so just be wary of that. Employee records must be accessible by WHD of DOL for inspection. The employer may be asked to compute or transcribe these records if necessary, and records should be kept at the main place of employment or the central records office. Okay. Last but not least, with FLSA, we will be talking about Nursing Mothers Act, also known as the PUMPed Act. This has been, again, a recent addition to FLSA. About last year, December 2022, President Biden signed the Consolidated Appropriations Act into law, which included this act, the Nursing Mothers Act. Nursing mothers must be provided with an adequate amount of break time or times to allow them to express milk. Employers must provide a space other than the bathroom to nurse that is not intrusive to the public or other workers. This is for nursing mothers of up to 1 year after birth. An important factor with the break time is that the employers must provide this time, completely relieve them from their duty or pay them for the time or for the break time, the same way that you would pay and compensate for the other breaks. Okay. Next slide, violations and retaliation. Violations of FLSA may result in monetary penalties, imprisonment, and corrective measures to ensure the violation does not reoccur. Statute of limitation for the recovery of back wages is 2 years for unintentional violations and 3 years for intentional violations. What's unintentional? Some examples are clerical error, administrative oversight, employer that's not aware that someone was misclassified, things that are considered intentional, obviously not a clerical error, something that the employer chooses to do. For example, making all salaried employees or all employees salaried because it's easier. Retaliation. Under FLSA, it's a violation to terminate or in any other manner discriminate against an employee for filing a complaint or participating in a legal proceeding. Employees ordinarily bear the burden of proof under FLSA, but the employer may be obligated to give employees access to work records so they can attempt to prove their claims. Okay, monetary penalties. In 2021, the DOL collected $234 million in back wages for nearly 200,000 employees who were paid unfairly. Yearly, there are 6,000 lawsuits alleging FLSA violations filed each year in federal courts throughout the country. In early 2023, the penalties for willful, again, intentional violation of minimum wage and overtime increased $2,300 per occurrence. Other penalties included are violating child labor restrictions, in which the employers received a maximum penalty of $14,000 to $15,000 per situation. So for any repeated or intentional FLSA violations, the maximum has increased from $2,203 to $2,374 per occurrence. Anytime someone who is paid incorrectly, say that you have a biweekly payroll, it's $2,374 times 26. Again, that's a lot of money for employers. Posting requirements. FLSA requires employers to display the current version of FLSA compliance posters. You can check this out on WHD website, or purchase a 1-year compliance posters, which includes all of the listed compliance postings, which you can see right here. Awesome. So FLSA does not include payment for hours not worked. For example, vacation, holiday, severance, sick pay, and the other listed categories here. FLSA does not allow deductions for lost company equipment, damaged tools, equipment, keys to building. You cannot hold or withhold final pay for any of these reasons either. If the employee agrees in writing for for these deductions, you may do so. Here are the common mistakes employers make with FLSA. This is what we see daily: placing too much importance on job titles or even job descriptions that do not accurately reflect the daily functions, making assumptions that all admin positions qualify for admin exemptions, making assumptions that all executive positions qualify for executive exemptions, and misclassifying the employees. Okay. Here are the proposed DOL rule for 2024. In August of this year, the DOL announced the new proposed rules restoring and extending overtime protections for 3.6 million salaried workers. What does the new proposal consist? There's an increase to the minimum salary level. It's going from must earn $1,059 per week, which is about $55,000 a year. Again, the current annual rate is about $35,000, rounding up $600 a year. It's going up to $55,000 a year. Okay. There's an increase to the threshold for the highly compensated employees, HCEs. The Department of Labor is revising the salary requirement for the HCEs, again, which currently is set as $107,432 per year. The new proposal is suggesting $143,988 per year. Territories and special salary levels restore overtime protections under the U.S. territories. There's going to be, the last update is for the automatically update of salary threshold every 3 years to reflect on current earnings, meaning there's going to be an automatic increase every 3 years. As a result of these increases, salaried exempt employees making less than the $55,000 amount would either have to increase their annual salary to $55,000, or they will become eligible for the overtime pay under FLSA for hours worked over 40 hours. Okay, now we'll open up for questions. If there are any questions, please type them in the chat box.
I will be collecting the responses in the chat. If anyone has any over the next few moments, feel free to type your message and select send question to staff. And then I will be able to select a few. Thank you all. Okay, we have a few coming in. The first one that I see is regarding the presentation itself, actually. Will the slides be made available? So the answer is yes. We will be sending out a post-webinar email. So tomorrow you should get that in your inbox. And we will also have the slides available on our website for your viewing, and you can download that. So yes. I'm also seeing another question. Sophia, where can we find more information about FLSA?
So going to the direct source is the best option. You can type in your web browser FLSA, WHD, DOL.gov, and you will have Department of Labor's website directly, or if you want the full web link, it's dol.gov/agencies/WHD/FLSA.
Okay, we have another. What does this new proposal, the DOL proposal, mean for me?
So if you have exempt employees who are currently making under $55,000, start having an action plan to start increasing their wages to meet the proposed requirements, or transition their exemption status to non-exempt.
Okay, we have a few more. How likely is the increase?
I'm sorry, could you repeat the question?
The person who submitted this, if you could potentially elaborate in the chat, it just says how likely is the increase. I'm assuming that might mean in regards to minimum wage, the $55,000 for salaried staff. How likely is that? Is what they're asking.
If I'm to interpret the question, how likely is this proposal going to pass? Most likely it will happen towards the end of the first quarter of next year. Currently, there hasn't been any updates. I know that as of November 7th, the comment section, the commentary section has ended, and we are waiting for the updates.
Awesome, and that answers another one of our questions about the proposal and if it's final or not. Perfect. If anyone has any more questions, feel free to submit those in these last couple of moments. I'm also seeing one that that asks about salary. And Sophia, I was wondering if you could potentially elaborate, or if this would be the sort of thing that perhaps someone would want to seek counsel from Monarch or another individual, this person asks why salary for all employees is a violation. If you have any insight on that, or anything regarding salaries and why all salaries for everyone is a violation.
So again, FLSA defines that if you are to pay your employees a salary basis, they need to pass the exemptions that the exemption tests. If your positions that you are paying salary for, if they are not passing those tests, most likely you need to pay them as non-exempt, which is their hourly rate, plus the employees qualify for earning overtime wages.
And I would like to just elaborate on that just a little bit. So according to the Department of Labor, every employee can be paid as non-exempt or hourly. The purpose of these exemptions is actually a benefit for the employer. For these specific positions, whether they're under the executive, professional, administrative classifications, it's a different type of work, right? So to benefit the employer with that intellectual type of work, Department of Labor says you can salary them, but at a certain level, which Sophia went over earlier. The purpose of the law was to protect those who do manual labor, anything that's not at that higher level of work, which is where the minimum wage protections come in, and that's where the overtime protections come in. If your employees that you're looking to classify as exempt or salaried do not meet those exemptions, then they are one of those, they're in that class of protected employee according to Department of Labor. If you do need to have any more discussion about this, you can absolutely give us a call at Monarch. We have experts in compliance and every state law as well. So we can kind of help you decide or help you classify those employees.
Perfect. Well, thank you so much, Dan, for that elaboration on that one particular question. And thank you, Sophia, for your time, for answering all of those questions for our attendees, as well as presenting all this information and all these insights for everyone, because I know that FLSA can be quite complicated. So going into 2024, knowing these changes in advance ahead of time is very important. So last but not least, we'll give y'all back just a couple of moments, and we wanted to make sure that y'all had a way to contact us. If you want to reach us, you can give us a call at either of these numbers, or we're just a quick Google search away and you can find our website, LinkedIn accounts, and reach out. Once again, we thank you all for your attendance this afternoon, and look for an email from us tomorrow with the recording and/or the slides. Have a great afternoon, everyone.
Thank you.